Hi, welcome, Namaste. In this edition, I'm going to talk about the rights of the minority community women. As we all know that in 2015 we are completing this is the 38th anniversary of the Shah case. We all know what happened in the Shah case by Supreme Court. It was a historic judgment in terms of individual rights and the women equality in India. Women equality and individual rights in India. Let me give you a brief. Shahabano was being divorced and she asked for the maintenance. Any woman person is entitled to the maintenance from the head of the family. Now, the civil code in Muslims is being formulated by the All India Muslim Personal Law Board, right? And according to the law board, husband is entitled to give the maher plus the another thing is iddat. Iddat. Maher is the one-time payment if there is a divorce. In the condition of divorce, maher is a one-time payment in Muslims, as well as iddat is the maintenance, and this is usually for the 3 months period. And along with that, the divorce can be given just by saying 3 times talaq, 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 right? So this is what it is according to the All India Personal Law Board, Muslim Personal Law Board. Here in 1985, Supreme Court had granted the maintenance beyond what All India Muslim Personal Law Board has to say. So we all know the political reality of the country and the lack of guts for social reforms in the country with our politicians. They are the vote bank calculators. They do not have the guts of, let's say, Dr. Ambedkar for the social reform. And we have seen that in 1986, the government came up with the act that effectively nullified the Supreme Court judgment. Here it was the rights of women, divorced women in Muslims. It was 1986 Act. So this is the background of that act. And after that act, it is not the government which had taken the path of making an individual realize their rights of equality and a life with dignity and respect. And you must note that in 2001, Supreme Court had effectively rendered the 1986 Act ultra vires because it mentioned that the Muslim Women Act, this is the 86 Act, has to be read in consonance with the rights given to an individual in Part 3 of the Constitution. Part 3 in the Constitution, the fundamental rights, right to equality, Article 14. Then right to life with dignity, Article 21 and 14. So any act has to be read in consonance with this. So Muslim Women Act, it was effectively nullified by the Supreme Court. Along with that, there were many orders, judgments by the Supreme Court that helped the minority women in realizing their rights. Recently, Supreme Court had mentioned that under the section 125 of CPC, Muslim women can ask for the maintenance. And the same is extended for the children, parents. Alright. Apart from this judgment, in February 2015, there was a case, the name of case Khurshid Khan versus the state of UP. Here, Supreme Court had mentioned that polygamy is not polygamy is marrying more than one woman. It is not the internal part of the religion. Internal part of the religion. What Mr. Khurshid Khan has to say that he has every right under the Article 25 of the Constitution. You may be knowing that Article 25. Let me take a different color here. Article 25 grants every individual the right to propagate, preach and practice their religion, practice of the religion, and there cannot be any interference. So under this article, this Mr. Khurshid Khan had mentioned that he has every right to have more than one wife, but Supreme Court had mentioned that this is not internal to the religious practice. Religion allows polygamy does not mean that it sanctions it. That's what Supreme Court had observed. Another important case is Shabnam Hashmi versus State of UP. Here, the case was that Shabnam Hashmi went for the adoption of a child. Now, Muslim personal law does not allow you to adopt a child for women. Now, here, court had mentioned that since she came to the court, it is her decision, and as an individual, she had taken the decision knowing the individual rights. It says that the personal belief and faith must be respected, but it cannot come into the way of enabling statute. And the enabling statute is the Juvenile Justice Act, because under Juvenile Justice Act only you can adopt a child. Now this is an enabling statute, and under this any person belonging to any faith can adopt a child if they follow the prescriptions, if they are eligible according to the law. So this law shall prevail on anything else. Another important act was related to Sharia. The fatwas, you may be knowing, the fatwas were being issued against many individuals. Court had observed that fatwas are an informal system, and if fatwas come into the way of individual rights, they are illegal. If any fatwa is against the individual rights granted under the Constitution, that is illegal. That's what Supreme Court has to say. But Supreme Court refused to ban all the fatwas. It refused to ban the fatwas on the grounds that these are the informal systems. Informal systems working for delivering a kind of justice. Even if that justice is against the fundamental rights, then certainly yes, any individual can approach the court and ask for the protection from the state. The bigger question is that this is the case of Supreme Court's activism. Though many people may say that Supreme Court is interfering in the matters, religious matters of the people, of the community. Now, this activism had helped a large section of the society realize their rights of equality and a right to life with dignity. That's Article 14 and Article 21 of the Constitution of India. Now again, question is what has to be done? What else can be done? Article 44 mentions the Uniform Civil Code. Let's treat all women, all men, third gender equal. Uniform Civil Code. Right? What else? There is a need to relook into the personal law. You might have heard of Safia Niaz. She is from Bharatiya Muslim Mahila Andolan. It's a strong organization of more than 15,000 women, and they constantly fight for the justice of the Muslim women. Sorry, it has 45,000 members. And in Lucknow, there is a women organization. They have evolved. They have formulated their own personal law in the spirit of Quran. A marriage contract, Nikah Nama. The name of this is Nikah Nama. A type of marriage contract. it includes many provisions which are in conformity with the Supreme Court judgments. Even the triple talaq argument, where Supreme Court had mentioned that just by saying talaq 3 times does not amount to the dissolution of the marriage. There should be a valid reason. There should be a valid reason behind it, right? A logical reason. And apart from these, the solution lies in the maturing views of the individuals and the groups who are fighting for the rights of the individuals and the communities. That's all. You can like our Facebook page. It's facebook.com/ias.tos. On Twitter, twitter.com/ias.tos. Okay, bye bye. Have a nice time. Thank you. In this, the source for this video was Live Meet. Thank you. Bye bye.